एक मिनट, हाँ.
Very good afternoon to all. I, Dr. Abhishek Kumar Singh, take this privilege to introduce Dr. Anurag Deep sir. He is currently serving as Associate Professor in Indian Law Institute, New Delhi. He completed his legal education from Banaras Hindu University with merit scholarship. He earned his PhD degree from Deen Dayal Upadhyay, Gorakhpur University on the topic Law Regarding Terrorism and Violation of Human Rights with special reference to cyber terrorism. He started case-based method of teaching in Gorakhpur University by providing cases of Supreme Court in Hindi medium for non-English medium students of rural areas. With teaching experience of 18 years, he has over 50 publications in English and Hindi, including the Journals of Indian Law Institute, Annual Survey of Indian Law, ISIL, Yearbook, Yojana, and Pratyogta Darpan, LexisNexis, etc. Members are published by government.
Sir, again because of a technical glitch, Abhishek sir
कोई बात
has
नहीं,
unmuted himself.
कोई बात नहीं. I think introduction is done. If you allow me,
Yes,
and
sir. Yes,
if
please
you
kindly start, sir. जी, sir.
yes, if you can upload the PPT, तो
Yes.
हम शुरू करते हैं, क्योंकि देखिए
Okay,
10
sir.
मिनट हो गया ये. जी जी.
Yes, sir. I'm starting. Yes, sir. We have started, sir.
ठीक है. So a formal good afternoon to everyone. At the outset, I must thank Integral University, head of the department, their team, learned faculty members, technical staff, and others who are engaged in this pious job of FDP. I am happy to learn that there are participants who are not only learned faculty members but PhD scholars also, and there are learned members also from foreign countries. So I should make it clear that it is an FDP. FDP does mean Faculty Development Program. It is not a lecture only that we usually deliver in the class. The whole purpose is that it is a program where faculty develops their intellectual, their academic potential. And therefore, faculty includes me also. So this is also a development program for me. So I'd request you to participate. Of course, in the end, there would be a question answer session and comment session. But maybe sometime I may pose a couple of questions sometime. I would request you to participate so that this is a two-way traffic, not just one-way traffic. That will ensure that it is a faculty development program. Now, first is the topic is human rights to free speech, and first important point is human rights. Now, the human right is not a word that is new in the academic dictionary. We have heard it many times. We have used it seriously, sometimes casually, sometimes politically. So this word has been used in many sense. So let us try to understand what is the meaning of human rights, especially in Indian context. So we all know there is a declaration of universal declaration of human rights, but that does not give you any exact definition of uh, human right. Madam, am I online? I think there is some. Should I continue? Uh, yes. Can anyone confirm that? Should I continue or should I just wait?
No, sir, you are online. You can continue, sir.
I can continue. I can continue.
Yes, sir.
Okay. So if the PPT can be displayed, otherwise I can on my PPT and do it.
No, sir, it will
The
be
PPT.
displayed.
Okay. So I was just discussing with you all friends that human right is something which is 1948 Universal Declaration of Human Right was agreed upon, and but there is no definition. We have ICCPR, we have other conventions, but there is hardly any convention which describes what human rights is. But we all understand what human rights. Human rights means rights of human being. That is the most semantic definition which can be given. But then when we say rights means what type of rights are they? Means rights which are required for human being. Then a number of rights are there. Then when we discuss definition, we should discuss limitations also. And limitations. So we will discuss the Indian context. Fortunately, we have a definition. And we can find a definition under Protection of Human Rights Act 1993,
Mail.
Section 2(1)(d). But before this definition, in 1993, we had our constitution in 1950. So quite back, around 43 years back, we already had a great document, Constitution of India, which recognized various human rights. And human rights in our constitution have been recognized at many places. Fundamental right is one place, which is in part 3rd of the constitution. Directive principle is second place, which is in part 4th of the constitution. Then there are other provisions, other parts also. Election Commission chapter, there are certain rights. We have property rights. Various other rights are there at various places. So human rights, indeed, our constitution is itself a human rights document that was prepared in 1950. And it was not a weak document. For example, you take UDHR. UDHR is not an enforceable document. Nobody is bound by UDHR. But take example in our country of fundamental right under part 3rd of the constitution. This is not only an enforceable right, but it is enforced by Supreme Court of India, High Court of India, and Supreme Court of India or High Court of India is bound by that. So our constitution had human rights. So part 3rd contains enforceable human right. Part 4th contains non-enforceable human rights. Non-enforceable does not mean it is not enforceable at all. It is enforceable, but not enforceable by court of law. It is enforceable by the government. So fundamental right part 3rd is enforceable by the court, while part 4 is enforceable by the government, not by the court. So when we talk about human rights in India, the journey starts In the democratic country, in the independent country, the journey starts from 1950, not 1993. Let us come to this definition of human right. Now, what is this definition? This definition is that rights are what are rights? The rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants enforceable by courts in India. So, let us analyze it. Rights means what type of rights? Rights relating to life, liberty, equality, and dignity. Four types of rights: rights regarding life, rights regarding liberty, rights regarding equality, and rights regarding dignity. But does it mean that human right in India is limited to only four rights? No, not at all. There are two reasons for it. Number one, because life, liberty, equality, and dignity, these four are just a type of uh, torch bearers. They do contain various bouquet of human rights. Life includes environment also. Life includes education also. Liberty includes all types of liberty. That includes freedom of speech and expression also. Similarly, equality means classification should be done only if it is essential, and say there should some rational. There should not be any arbitrariness. Dignity has become a part of life. So, uh, when we say life, dignity, many other rights are involved in this. This is one reason. What is the second reason that human rights are not just limited to these four? The reason is the words used are relating to. Rights relating to. It does not say the right to life, liberty, equality, and dignity. It says rights relating to. Relating is a broad term. Anything that is relating to life, anything that is relating to liberty, anything that is related to equality, anything that is related to dignity is a human right. It's a human right in India. But then comes some limitations. What are the limitations? These must be guaranteed by the Constitution. So all rights are not human rights. Only those rights which are guaranteed by the Constitution of India. What are the rights guaranteed by the Constitution of India? Fundamental rights. Part third of the Constitution of India is guaranteed, and other rights are rights, but they are not guaranteed rights. No guarantee has been given by the Constitution regarding enforcement. Of course, government or the state is bound to do it, bound to follow rights given under directive principles. But only those rights which are guaranteed by the Constitution, they are part of human rights in India. So, in other words, if they are not guaranteed by the Constitution, unfortunately, they are not human rights for the purpose of India, because the definition itself is guaranteed by the Constitution. Secondly, embodied in the international covenants and enforceable by courts in India. So, in the international covenants, ICCPR, Economic and Political Rights Covenant, these covenants, all rights which are included in these covenants and enforceable by courts in India, not only included in these covenants. There are a number of convention covenants. There are two types. One which has been signed by India, others which have not been signed by India. One, for example, Torture Convention, which is signed by India but not ratified by India. So, Refugee Convention, neither signed nor ratified by India. So, there are various international covenants. Uh, so, whether these covenants, rights under these covenants are enforceable by courts in India, and how the courts make it enforceable if there are laws made. For example, take example of Sexual Harassment Act. There is CEDAW. Now we have made a law also. So sexual harassment rights are enforceable by courts in India. There are many other rights. Uh, so there are two types of rights. Either they are guaranteed by the Constitution, or they are international covenant and enforceable by the courts in India. They are human rights. Rest of the things may be said to be human rights in international sense, but they are not human rights for the purpose of India under protection of Human Rights Act. Next slide, please. Next slide.
Yes, sir.
Yes. Now, uh, under as I discussed with you, the international level there are various rights. UDHR is one of them, and freedom of speech and expression is also provided. Other rights are also provided, and we often discuss it, but we often forget there are limitations also. And rights are rights are rights are equally important, and gender limitations are equally persuasive. We should not think that only rights are important. Indeed, limitations are also important. So, limitations make a discipline of rights. We all know without discipline, nothing can progress. In our life or your life, nothing can progress if we remain without discipline. We often go to our roads, and if we start driving uh, as per our will, someone is driving at 40, someone is 60, someone is 80. If we do not follow red lights, if we do not follow other instructions, what will happen? There would be accidents, there would be casualties. So limitations are essential. The way red lights are essential on the roads, the way speed breakers are important in the roads. Similarly, uh, with rights, limitations and restrictions are also equally important. Sometimes we forget about limitations, only talk about rights. So the first important thing that the takeaway for us is that rights and restrictions both are very important for us. We should know both and we should apply both. If we do not do it, then there would be chaos, there would be all disorder, there would be accident the way it takes place in on the road. So restrictions, now there are various restrictions. 29, Article 29 is one restriction. Article 30 also deals with some of the restrictions. So some of the restrictions on freedom of speech and expression that we are discussing, these restrictions are there in the international documents also, that we probably do not try to read into. Take example of ICCPR, which is available in the next slide. ICCPR. Special limitations are there on the grounds of national security. Uh, for example, Article 1 says all people have a right to self-determination. And by virtue of that right, they freely determine their political status, freely pursue their economic, social, and cultural development. When we talk about right of self-determination, this is a type of free speech. We express ourselves. We express ourselves. This is a right of self-determination. That does not mean right to secession. Right to self-determination does not mean right to disintegrate. Huh? Right of self-determination means we can determine our political right through elections, through electoral process, through participation in the electoral process. And that we do in India for last maybe so many years, last maybe so many decades we are doing it. And elections are by and large free and fair. And the indication is that in 1975, 1977, you see Janata Party won with a large majority. In 3 years, Indira Gandhi came back. Then in 1984, of course, we have lost a prime minister and there was a wave. Congress party again won. But later on, 1989, they lose and VP Singh came. Then we again find that in 1997, a new government came in. Then in 2004 or 5, we found again Congress party came in. It ruled for 10 years, and then now new government in the form of NDA or BJP is here. So what we find that the democratic process in India is one of the best way of right of self-determination. We all, be it in Kerala, be it in Jammu and Kashmir, be it in Northeast, be it in Gujarat, be it in Rajasthan, we determine. And we determine not only at one level, we determine at four level: panchayat election, municipal election, Vidhan Sabha election, and then Lok Sabha elections. So this is, but there are national security limitations. There's national security limitations. So next, I'm moving to the next slide. Then Article 4. Article 4 provides some of the right to some of the rights regarding derogation, that in the time of public emergency which threatens the life of a nation, then rights can be curtailed. So rights are given, but limitations are also given. Neither right is stronger nor limitations are stronger. Both are equally important. Let us see Article 12. Next slide. Article 12. Article 12 again says that rights are already declared, but then restrictions can be on the ground of national security, even on the public order. So I have a right to freedom of speech and expression under Article 19 in the ICCPR and the Constitution both. But then we cannot speak something that goes against national security. We cannot speak something that goes against public order. We cannot speak something that goes against public health. These days, it is COVID time. We cannot say that we cannot pass rumors about COVID. We cannot pass rumors about vaccination. Then against morals also, morality also, we cannot speak something which is completely immoral. So freedom of speech and expression is there, but this right is under restriction. Then freedom of others. We cannot do something, speak something, do something that infringes freedoms of others. So these rights are with restrictions. We have rights and we have restrictions. Take example of next slide. Take example of ICCPR Article 19. It says very clearly, everyone shall have right to hold opinion without interference. Article 19 says, ICCPR, everyone shall have right to hold opinion without interference. So we have, everyone means be it a foreigner, be it an Indian citizen. ICCPR gives this right to everyone, right to hold opinion. I can have any opinion which is something that you may not like, opinion that maybe my one religious leaders may not like, opinion that maybe political party may not like, opinion that maybe my family members sometimes may not like. So that way, right to hold opinion is there, and that too without interference. So ICCPR Article 19(1) says two important things. One, that it is available to all. ICCPR, I'm not talking about Constitution, please take note. And it says without interference. No interference should be there. But does it mean there is no interference? There are interference, and state can make interference. But I will come to that interference. Second is Article 19 second. Everyone shall have right to freedom of expression. This right shall include freedom to seek, receive, or impart information. Article 19 also talks about right to get information and information of all kind, regardless of frontiers, either orally or in writing or in print form or through any media. So I have right to get information, and this right to get information is not only against a state, it is against anyone. It can be against maybe non-state actors. It can be against a corporation. It can be against a university. It can be against a party. It can be against a media house also. So when we talk about freedom of speech and expression, it clearly says that these rights are right to information is against anyone. It does not say it is only against the state. So sometime when we talk about right to information, we should be very clear that the information may be sought from us also. Students can also seek information from us. Let me give you an example. Can a student seek information that on what grounds marks have been given? Whenever I go for evaluation, either when I do evaluation either at home or maybe in public service commission or other places, uh, we often think on that if the student asks me on what grounds you have given marks, because you, most of you, all of you are, I think, faculty members, this is a very serious issue. Indeed, teachers are judges who deliver educational justice at various levels in the classes, while we make evaluation, while we make take viva. So now I think this is the next development that academics should take place, that academicians should be more responsible when they deliver marks, when they evaluate, when they examine, when there is an interview. So in everywhere we have a right to know, that why my answers were wrong, how many marks were given, why is there such marks were given. But this right is something that probably many academicians won't like, but that is the next development that should take place. Let me also suggest you one thing. In Ajay Hasia case, Ajay Hasia versus Ajay Hasia case, the Supreme Court in late 1980s has suggested that some recording should be done of interview. That was a case of Jammu Kashmir, where in engineering college certain questions were asked and answers were given, but very meritorious students could not be selected. Then some of them challenged it, and the court said that what are the questions which were asked, and the officers and the authorities were not in a position to answer. Then they suggested that why you don't record it. So 1980s to 40 years have gone. Now we have video recording. Now we have online recording. So Article 19(2) suggests me that if we are really a soldier of freedom of speech and expression, then the beginning should be made from ourselves. We should make ourselves more and more accountable, more and more responsible. We should give information and we become more and more accountable. So this is a new thing that I wanted to incorporate in this discussion. Third is the exercise of Article 19(3) of ICCPR says the exercise of rights provided for in paragraph 2 of this article carries with it special duties and responsibilities. So it is subject to certain restrictions. What are restrictions? Respect of the rights and reputation of others. When I speak something, I must respect rights of other persons are willing to speak, but I'm not allowing them to speak. What is happening? That is happening here. In you see some news channel, sometime in parliaments also we see, sometime in discussion also we see, we don't allow others to speak. So we should respect the rights of others, and more importantly, reputation of others. Don't write something, don't speak something which challenges the reputation of someone. That is happening every day on Twitter, on Facebook. These days, we write so many things. Without any accountability. And you can go and you can see what type of things we are writing. Suppose we do not like some article, we start speaking like anything. If sometime we say, immediately declare them कि कोई गद्दार है, that they are traitor. Sometimes we say they are deshdrohi, or sometimes they say they are chamcha of Modi. But we should not. We should be decent in our reactions. So if we are not decent in our reactions, we in the name of free speech, we challenge the reputation of others. Then in that case, telling someone the political bhakt. So if we say like this, then I think that is against the reputation of that person. For next limitation is, which is available in the Article 19(b), national security. We cannot speak something against national security. Freedom of speech and expression does not give you something to speak on national security, which goes against national security. Of course, if you are writing something on national security, so that national security is improved, that is always welcome, that is always permissible. But you cannot just say anything about national security which goes against national integration. Uh, so, so if the boundary is crossed, there are laws that comes in picture. Similarly, public order. We cannot say something that disturbs public order. We cannot say something that disturbs public health and morals. That I have already discussed with you. I come to the next slide, Article 20. And you can see any advocacy. So, any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence must be prohibited by law. Article 20 of ICCPR says that there is a law that should prohibit it. So you cannot make advocacy based on based on national hatred, religious hatred, racial hatred. So that type of advocacy should not be there. And if we are doing it, that is against violation of Article 20. So I'm then moving to the next slide. Uh, Article 22 talks about freedom of association, which is another form of freedom of speech and expression. Freedom of speech and expression. And this also says that restrictions should be there, but restrictions should be limited and only on certain grounds. Now I come to the fundamental right part. I was discussing what is human right. This was the discussion on human right. So I told you that human rights are available in human rights document, but all human rights are not human right for the purpose of India. They are given, but they are not applicable for the purpose of India. Only those which are provided under Protection of Human Rights Act 1993 are human rights, not all human rights. And when we talk about human rights, there are restrictions also that we should be aware of. Now, let us come to the freedom of speech point. What is freedom of speech and expression? Freedom of expression means you express yourself, and you can express yourself the way I am speaking, or you can write something, or you can make a cartoon. So drawing is also a form of expression. You can go for drama. So drama, television, and movies, they are also a form of expression. There are various forms of expressions. And so freedom of speech and expression is recognized in our constitution in 1950. 1948 ICCPR recognized, and 1950 our constitution has recognized it. But it is not recognized at one place. Freedom of speech and expression is recognized at least at 3 places. You see the preamble, and preamble says freedom of expression, thought, and belief. So preamble itself says in the beginning, it declares in the constitution in the very first page that freedom of speech and expression is so important for us. Then Article 105(1) or 194(1), where special rights have been given to our representatives. Not only representatives, anyone who has authority or right to participate in the proceeding, he has special right. So special right is provided to our representatives beside fundamental rights. Then but and then Article 19. Article 19 contains fundamental right. It has 6 rights, but 19(1) is freedom of speech and expression. So you have freedom that you can speak something and you can express something. But one thing is very clear: it is available to citizens only. I discussed with you when I was discussing with you ICCPR. It was available to all the persons, whether they are citizens or foreigners. So fundamental rights in India freedom of speech and expression is not available to every person. It is available to citizens only, unlike ICCPR. So you can make clear distinction between human rights and fundamental rights. So when we say human rights, we often forget that human rights are limited. It is not human rights in the international sense. Why? Because our constitutional framers, in the leadership of the great visionary like Dr. Ambedkar, has made it available only to citizens. Article 14 is available to all the persons, maybe citizens or non-citizens. Article 21 is available to all the persons, maybe citizens or non-citizens. But Article 19 is available only to citizens. Foreigners cannot claim fundamental right to speak and expression. That does not mean they don't have right to speech and expression. They do have, but it is not fundamental right. When we say it is a fundamental right, what do we mean? Our meaning is very simple. Number one, that fundamental right means you can directly approach to the Supreme Court that the rights are violated, and Supreme Court will make declaration. Secondly, Parliament cannot pass a law which violates fundamental rights. That is the beauty and that is the strength of fundamental right. So it is available to citizens. Second important point is, when it is available to citizens only, we all should understand that company and corporations are not citizens according to constitution bench judgment. Company and corporations are not citizens at all. So Bennett Coleman company, which publishes Times of India, Indian Express, NDTV, Republic TV, they all are corporations and companies incorporated by one means or other means. So as a city, because it is available to citizens only, and corporations are not citizen, therefore they cannot have fundamental right to freedom of speech and expression. But then that does not mean they do not have fundamental right. Supreme Court has held in many cases that press has fundamental right to speech and expression under 191A, and not the corporation can claim fundamental right, but their stakeholders, their editors, their writers, their shareholders can claim that fundamental right because they are citizen of India. So Article 19 has first limitation. It is available to citizen. It is not available to all persons. It is not available to corporation and companies. It is indeed not available to press if they are in form of corporations, but it is available to press if you are an editor, if you are a writer, if you are a shareholder, it is available. What is the next important restriction? Next important restriction is that restriction can be on 8 grounds. 8 grounds. What are 8 grounds? Sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement of an offense. So you see that on freedom of speech and expression, there are not one, two, three, four limitations. There are 8 restrictions, and if we want to speak, we can speak, but our speech should not go against sovereignty or integrity of India, against friendly relations, against public order, against decency or morality, against it should not be contemptuous to the court, it should not be defamatory, it should not incite an offense. These are the restrictions. Then fourth important point is, restrictions are there, but should the restrictions be only on the ground of public order, only on these 8 grounds? Only on these 8 grounds? The answer is no. Why? Because the word used is in the interest of. You will see in this slide, freedom of expression slide, you can see that yes, which is slide number 12, that uh, that the grounds are not it is directly sovereignty integrity, but in the interest of. What is the meaning of in the interest of? In the interest of makes it far wider, very wide. The first Supreme Court judgment on that describes in the interest of is Ramjilal Modi. Ramjilal Modi case, and in this case, it was again interpreted that 8 restrictions can be wider because they are the word used is in the interest of, it is not only sovereignty integrity. So anything that may be in the interest of public order, uh, it is not necessarily the public order is directly disturbed. If there are apprehension of public order disturbance, if there are apprehension of sovereignty and integrity of India being disturbed, if there are reasonable apprehension that something goes against morality, if there are reasonable apprehension of contempt of court, if there are reasonable apprehension of defamation or incitement of offense, then in that case, the restrictions can be imposed because the word used is in the interest of. So these are the power of the state on which restrictions can be imposed. So there are 4 types of power, I would say, if I analyze in conclusion of this part, that it is available only to citizen, it is limited right, and it is available to press, but not in the form of corporation. And third is that 8 restrictions are there, and fourth is in the interest of makes it wide. Does it mean our rights are very restricted? No, not at all. Supreme Court has interpreted in many cases that when we want to impose restrictions, the first thing is that it must be reasonable restriction, not every restriction. It must be reasonable restriction. You cannot just in the garb of sovereignty integrity, friendly relations, decency, morality, contempt of court, defamation, incitement, you cannot impose any restriction. It must be reasonable restriction. Hmm? Secondly, the courts have said that when the word in the interest of used, that does not mean you keep on imposing restriction. Restrictions must be proportionate. Only that restriction which is reasonable in nature, which is required. So suppose there are 3 ways to make restriction. You have to use that way which is least intrusive, so states have to follow certain norms. Number 1, that it has to be reasonable. Number 2, it has to be proportionate. Number 3, it is not something that you should be very delicate. You are very delicate and suddenly you think that no, it is violative of. No, that is not like that. So restrictions can be there, but restrictions have various categories. I'm moving to the next slide, but I'm skipping this because I've already done with. What I wanted to discuss in this slide, you will see sovereignty and integrity of India word is used. Let me tell you, friends, that in 1950, when the constitution was made, we had certain restrictions. But in 1951, we had added further restriction. Why? Because in 1950, 2 judgments came. One was Romesh Thapar, another was Brij Bhushan. Due to both the judgment, the Supreme Court held, number 1, that right to press is a fundamental right. This is what. But the Supreme Court also held that public order is not a ground, and therefore restrictions cannot be imposed on the ground of public order. I am going back to slide to show you that public order is a ground here in current constitution, but in the original constitution, public order was not a ground. Sovereignty and integrity of India was not a ground. So public order as a ground was incorporated in the first amendment, public order and as a ground of restriction. Similarly, through 16th Amendment 1963, sovereignty and integrity of India as a ground was incorporated, and this restriction was imposed not only on Article 19.2 but on 19.3, 19.4 also. 19.3 deals with assemble peaceably. 19.4 deals with form of associations. So what I find that our constitutional journey started with freedom of speech and expression, but with the passage of time in 1951 and 1963, our restrictions were increased. So Now I have dealt with this thing. I am on limitation and restrictions on human rights. I have discussed with you what are the limitations and restrictions of human rights. I have already told you the difference between fundamental right and human rights, that human rights are limited, fundamental rights are broad and powerful, in the sense that fundamental rights, no law can be made which violates fundamental rights. Now I come to the model. Three models are there of free speech, human rights to free speech. There are three types of model. First model is American model. Second model is British model. Third model is Indian model. What is American model of free speech? American model of free speech is very wide model, very broad model. It is said to be an ideal model. What does American model says? American model says that the fundamental rights are absolute in nature. So it is absolutist model. Why it is absolutist in nature? It is absolutist in nature because uh, fundamental rights or Bill of Rights in America is incorporated through first 10 amendments in the US Constitution in 1791. But it does not contain any restriction. First Amendment contains free speech and other things, but there are no restriction at all. So therefore, because there is no express restriction, American model is said to be an absolutist model. That does not mean there are no restrictions. Supreme Court has carved out various restrictions through its judgment, like police power doctrine and others. Second is British model. British model says no fundamental right, no expressly recognized fundamental right. In America, no express restriction, only fundamental right. In Britain, no fundamental right at all, because there is no written constitution. There is no fundamental right. So if a law is made by the parliament which violates human right and maybe fundamental right, no one can declare it unconstitutional. Even the House of Lords, now Supreme Court of UK, that cannot declare it unconstitutional. Of course, they can declare it maybe incompatible, but they cannot declare it unconstitutional. So in America, if a law is made against fundamental right, it can be declared unconstitutional. In India also, it can be declared unconstitutional. But in Britain, Parliament is supreme and as a matter of fact is sovereign, and and cannot be cannot a fundamental right cannot be declared in Britain as a law cannot be declared as unconstitutional because there is no fundamental right. So American and British model are in a sense contrary to each other, but does not mean Britain do not have rights. Britain has no written constitution does not mean Britain has no constitution. They have unwritten constitution. America has unwritten restrictions and very powerful restrictions. Britain has unwritten restrictions and they are very powerful. Powerful rights are there, but they are not in the nature of fundamental rights. Not in the nature of fundamental rights. Now we come to India. Indian model is a hybrid model. Hybrid model. Why? Because Indian model has fundamental rights written. Fundamental rights are written like America, but restrictions are also written, and Parliament can incorporate restrictions through the Constitution. Through the Constitution. So, like UK, where Parliament, there is no fundamental right and Parliament is sovereign. In our country, Parliament is not sovereign. Parliament is bound by the Constitution. So Parliament, if makes a law, it has to make a law as per the dictate of the Constitution. It cannot surpass the constitutional law. So therefore, our model is a hybrid model. It is a RWR, right with restriction model. American model is a rights model. British model is a restriction model, restrictive model. Indian model is a rights with restriction model. So that we need to understand. So friends, now I go to the next slide, and I think Can I be informed how much time I'm left with?
Sir, we have enough time. You can complete your.
Means uh,
Sir, we have almost 20 minutes. We can
20 minutes
complete.
more.
Yes.
20 minutes.
Yes.
Okay, okay.
Yes.
ठीक है, ठीक है, ठीक है. So now we, yes, this slide is good. Can yes. So I will just finish in 10 minutes and 10 minutes for discussion. So can you just move to the previous slide? I'm not going to cover all slides because of lack of time, but I will discuss. Yes, 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 yes. Now, what is the scope of this freedom of speech and expression? Now, this is very important. Sometimes we say that, can I speak against police? Can I speak against the prime minister? Can I speak against the chief minister? Can I speak against the president of India? Can I speak against the Supreme Court? Can I speak against religion? Can I speak against spiritual gurus? The answer of all questions are, friends, yes, yes, and yes. Freedom of speech and expression does not only mean you express and you speak something. It does not only mean that you discuss the way I discuss with you and you discuss with me. Freedom of speech and expression, the test is whether you can disagree or not. Can you have dissent with me or not? If you cannot have dissent with me and I do not respect your dissent, that means there is no freedom of speech and expression. Can you disapprove me? You can say that, Ragdeep sir, I do not agree with you on this point. I disapprove. Yes, you have this right. And this is a matter of right. This is not something, a type of bounty or gift that is given. This is not something that something etiquette wise I am doing. It is a matter of right to disagree with the government, to disagree with religious books, to disagree with the prime minister, to disagree with the chief minister, and to criticize the police and to criticize the police commissioner. So this can be done. So not only against the state and the instrumentalities of state. So DM, CM, and PM all are subject to this constitution, and our fundamental right is greater than any of them. So can I criticize an individual? Yes, I can criticize an individual. I may not like, some of you may not like me, and you can say, no, Anurag sir, I do not like your presentation. It was a very poor presentation because of following reasons. Can I criticize a community? Yes, I can. I can say that when in 1950s, Dr. Ambedkar tried to bring Hindu Code Bill, great number of conservative Hindus have attacked Dr. Ambedkar. That was completely unfair. That was a foolish act of Hindu community. Can we say that a Khap Panchayat pass dictates that don't marry here, don't marry there, and do this and do that? Is it good? I would say it is completely shameful. I can criticize a community for something among Hindu communities and also among Islamic communities. Dowry is there. Can we criticize that this dowry is completely a bad tradition? Yes, we can criticize. We can criticize a community. Can we criticize a group of Islamic communities, Islamic people, that they are supporting, some of them, not all, some of them are supporting instant triple talaq? Yes, we can criticize. Anyone can criticize. So can we criticize community? Yes, we can criticize. But when we pass our boundary in criticism, if we lose control and defame a person, then there are laws like 499 of IPC, besides civil law. In criticizing a community, maybe Hindu community, maybe Islamic community, maybe Christian community, maybe Jews, or maybe a caste community, if we cross our boundary and hurt religious feelings deliberately, want to demean them, then in that case we have section 153A of IPC, 295A of IPC is there. So we have right, but then we have restrictions also. As I told you, don't think about that we have only rights. We have restrictions also. Then can we criticize? Can we criticize institutions? Yes. Take two examples of institution. Can we criticize parliament? Yes, we can criticize parliament. What is this parliament? Parliament is our representative. We have sent our representatives there. So sometimes we'll see parliament के बारे में नहीं, उनके बारे में मतलब बहुत क्रिटिसाइज, बिल्कुल खुलकर क्रिटिसाइज कर सकते हैं पार्लियामेंट को. We can criticize this parliament. We can say that in the parliament there are certain people who are from criminal background, and therefore parliament is protecting those people from criminal background. Can we speak? Yes, we can speak. Can we say that parliamentarians are not serious in making laws? आज वो law बनाते हैं, today they make law and within 1 year they have to make amendment. So that shows that they are not doing serious business. The whole business of parliament is to make law, but they are not making serious business, only doing politics, only thinking about their elections. They are some of them are completely incompetent. Can we say? Yes, we can say, because I have a ground to say. So can I criticize an institution like parliament? Yes. Police is an institution. Can I criticize? Yes, we can criticize police, but we should have ground. We should not pass rumor. We should not say that we can say police, sometimes police works in a corrupt manner. Can we say? Yes, we can say. Can we say politicians are corrupt? We can say politicians are corrupt. Can we say that the court has failed in this responsibility? Yes, we can say. We can 100% say. Can we criticize a pending judgment? There are confusion even among law teachers. Many of them law teachers said, sir, ये pending case है, ज़्यादा बोलेंगे नहीं. हमने कहा किसने बताया आपको नहीं बोल सकते? Every day in the news channel, pending judgments are criticized. This is our right. This is the beauty of fundamental right under Article 19, that we can criticize the judgment which is given. Keshavanand Bharti can be criticized. Yes, can be criticized. A.K. Gopalan can be criticized. Yes, it can be criticized. Can Menaka Gandhi can be criticized? Yes, that can be criticized. Can appointment of judges cases be criticized? Yes, it can be criticized. Can a pending case be criticized? Of course, it can be criticized. There should not be any confusion. It is sub judice. It is sub judice for the parties, not for me and you. It is indeed it is the business of academicians, because you all are academicians. It is our duty to criticize institution. It is our duty to criticize Supreme Court. It is our duty, because that we are the pillars of checks and balances. Supreme Court judges and judgments, they have no checks and balances. Unlike Parliament, which is responsible to the Lok Sabha, and then every 5 years they have to go for elections, the Supreme Court judges are not responsible that way. So how to make them responsible? We make them responsible by criticizing their judgment, that we don't agree on this judgment, we agree on this judgment. This judgment is right and this judgment is wrong, but give certain grounds. So we can criticize the court. We can criticize the functioning of the court also. But take care, when we criticize the functioning of the court, we cannot find motives in the court. We cannot say that a judge has given a particular judgment because he wants to favor Narendra Modi. If we want to say so, we should have some ground to say. We cannot be hypothetical. We must have some ground to say, because it is defamatory. This is something like that. Suppose I and you are evaluating something, and suppose 5 students get good marks, 5 students do not get good marks. Those who are not getting good marks, they will say 5 students have got good marks because the teacher wants to favor. You can say so, but you must have grounds. You can say that the evaluation process is not fair. This thing you can say with certain grounds. So can we criticize the institution? Yes, we can criticize the institution, but in criticizing the institution, we should not cross boundary. We should not say this judgment has been given because judge is in favor of Phala party, or judge is in favor of that person or that person. Judge belongs to Congress party, therefore judge will give judgment in favor of Congress party. judge belongs to judge. This time judges are scared of Narendra Modi government, therefore they are giving all judgment in favor of you must have heard this thing these days, that there are a lot of judgment. We do not do research work, friends. A lot of judgment where the court has given judgments against the current government. Take example of NJSE. This is one example. The whole constitutional amendment was declared unconstitutional. Take example of privacy judgment. Government was telling that privacy is no right, but the court said the privacy is a right. Many judgments are there. Government was telling that 377 should not be decriminalized. The Supreme Court has decriminalized partially. Government was telling that 497 adultery should remain. It is good. It will disturb family structure. The Supreme Court has declared it unconstitutional. There are many judgments that has gone that has come against the government, but there is a trend in writing that we say that judgments are given because of. So if you say so, it is not that you cannot say so. You can say, but then you must have certain grounds. But if you say and other people think that it is disrespectful to the court, scandalous to the court, then contempt of court petition can be brought in, and you know why Prashant Bhushan was declared contemptuous, because he might have raised a good issue, but he has shown in a manner that as if Chief Justice is deliberately doing it. And factually wrong statement was given in the Prashant Bhushan case also, that Supreme Court was not working. Supreme Court was working. So last is, can we criticize state or not? State is all powerful. Yes, I can criticize the state. I can say that in last 70 years, India was not able to remove poverty. Many people are sleeping every day who are hungry. Many people are illiterate. Many people are malnourished. Many people are unemployed. State has completely failed. Can I say so? Yes, I can say. I can criticize the state for its failure. So when I say that freedom of speech and expression, that does not mean that we cannot criticize. Sometimes this thing is that we cannot criticize. Criticism is a fundamental right. Sometimes we say that for the criticism, people are arrested, people are FIR is registered. That is correct. That is misuse of law. But misuse of law is there, but that does not mean everything is a misuse of law. If you make some research work that we have made in ILI, a lot of things are written against the state, against the government. Thousands of posts come every day. One, two, three posts, the government takes action. Some of them are misused also. There is no doubt. Let me give you a small illustration. In Chhattisgarh, in 2019, against power cut, electricity cut, a person has posted a Facebook post, and he has told that the government, Chhattisgarh government is cutting this power, deliberately doing this power failure so that inverter company can get their benefit, so that their sale increases. If there would be no power, then people will go and buy inverter, and the government is deliberately doing it against the people and in favor of the inverter company to give them benefit. A sedition case was registered against that person in Chhattisgarh. So, of course, I understand there was freedom of speech and expression to criticize the government. Did that person cross that limit? Yes, that person crossed the limit. Because unless you have any ground, you cannot pass a remark that the government is doing deliberate favor. You should have certain ground. So when you pass an allegation, you should have certain grounds to pass an allegation. So this was, the person has crossed his limit. He could have said that government is failure. It is not giving power. Power is being misused in various places. And so you can say, but when you say that government is deliberately engaged so that benefit goes to a certain company, then you should have certain very strong ground, because you are passing some allegation. I told you, The way if I and you evaluate a copy and someone says that 5 students have been given good marks because they are close to the teacher wants to favor, you should have certain grounds. You cannot just pass any allegation just because you did not get good marks. So, but at the same time, I would say that sedition law was not a good law for that. That person has violated his limit. There is no doubt he has crossed the limit. He was passing rumor against the government, but sedition law was not the good law, and it is good that later on the government has taken back that 124A case. Let me give you another illustration. When Arun Jaitley was cabinet minister, NJSC judgment came in. NJSC judgment came in. I think I should, because 10 minutes have gone, I will just conclude. NJSC judgment came in. NJSC judgment means through 99th Amendment, National Judicial Appointment Commission was constituted through constitutional amendment, and an act was also passed. Supreme Court has declared it unconstitutional. Arun Jaitley has criticized the judgment on his Facebook post. It was criticism of the judgment, and judgment can be criticized. But what happened? A judicial officer in UP, he has noted, he has registered a suo motu case under sedition law. See how ignorant some of the judicial officers are. It is not only state, it is not only police officer, but even judicial officers, not all. Some judicial officers are not aware of. And ultimately the case went to High Court, and High Court said it is a type of criticism. Anyone can criticize a judgment. And he has only said that the judgment is wrong, and judges stay in ivory towers. They are not aware of ground realities. They think that only they can select right people. Government can also select right people. So freedom of speech and expression is there. And if there is no right to dissent, there is no right to disagreement, there is no right to disapprove, there is no right to criticize, democracy is weak and democracy is weaker. And no democracy can exist without that. Now the scope of this fundamental right goes not only to speaking criticism. Sometimes shocking, disturbing, and offensive statement can also be given. Sometimes, let me tell you, friends, even a false statement can also be given, which is protected. Let me give you a small example. Someone says a completely false statement that now 2 days are holiday, Monday and Tuesday are holiday. And he has passed this information in various WhatsApp groups. And he also said that government of India has declared 2-day holiday. What will you do? Nothing can be done. Nothing can be done if he is passing wrong information. So it is not that for this purpose sedition case can be registered. It is not that for this purpose 153A, 153B, 295A, these type of provisions can be registered. These are false information, and false informations needed to be ignored. Freedom of speech and expression to some extent also protect these type of things. You cannot criminalize. Of course, some civil action may be taken, but for these type of statements, sometimes the false statement is also protected. So I will just conclude with 3-4 cases, important cases. If you go to the next slide, yes, these 5-6 cases are very important to understand what is freedom of speech and expression and when does it crosses the boundary. So I have already told you there are 8 restrictions, and 8 restrictions are broad restrictions in the interest of should be there. But when you suppose there is a Facebook post, a WhatsApp post, suppose there is a video. In the video, a person speaks for maybe half an hour. And for 1 minute, he speaks something which you do not like, which is against Prime Minister, which is against Chief Minister, which is against district magistrate. Then what is the correct test? You will not say that this particular statement he has made and therefore he has crossed the boundary. No. Shalbala Devi versus the state of Bihar, which is also known as Bharati Press case, 1952. It is a constitution bench case. Write down. 1952 constitution bench case. It says there is a totality test. You will read the whole statement. You will hear the whole speech of half an hour. And if you find there are only 1 line, 2 line, 3 line which is objectionable, you cannot book a case against that person. Why? Because totality test is applicable. If in totality, if in toto the speech is good, it is just examining strength and weakness of the government, then there no action can be taken. You cannot pick up. Suppose a book is written. That book is in 300 pages. In 2 pages, something is written against religious thing, against our scriptures, against our religious leaders. You cannot ban the book just because 2 pages are written. If rest of the pages are okay, this is known as totality test. In toto, what is the message of the book? In toto, what is the message of the speech? In totality, what is the message of the post, Facebook post, or maybe an article? If the article in totality itself is very offensive, against national integration, against public order, inciting violence, against means is defamatory, then in those cases we can say that freedom of speech and expression has been violated. If you read the 2 tweets of Prashant Bhushan, both the tweets together, because in totality test, they indicate as if the Chief Justice and the Supreme Court is working with the BJP government, with the Modi government. And that's why Supreme Court has said that in totality, you have violated a contemptuous law, and therefore he was declared as violative of contempt. So in totality, but that does not mean that one line or 2 line you can take from that. Take example of recently decided case, Dua case, Vinod Dua case. Now in Vinod Dua case, a case was registered against him. He has made a video, and in the video, in totality, Vinod Dua has criticized the government for its handling of COVID and said that the central government has not handled the case properly. Supreme Court has said that there may be certain 1-2 sentences which may be not good, which may not be appropriate, but all the video is, there is nothing objectionable. The video only says that the central government has not handled COVID case. He has freedom to speech and expression. He has not said anything, and the Supreme Court said that if we apply in totality test, then in totality the post is, the video is not objectionable. Second is Ramjilal Modi 1957 that I already declared with you, decided that I also already discussed with you, that is said that everything that we think it is bad to us, we should not be worried about. Many things are said, many things sometimes against religion, sometimes against political party. We should not be sensitive enough. No, only aggravated form of departure should be considered as criminal. Otherwise, a person, sometimes he can speak something which I may not like, or you may not like, but we have to tolerate. Freedom of speech and expression means we have to tolerate. Third is Ram Manohar Lohia case. It is very, very important. There are 2 cases of Ram Manohar Lohia, 1960 and 1966 case. 1966 case is very significant, my friend, very significant. In 1966 case, the Supreme Court Ram Manohar Lohia Constitution Bench case says that there are 3 types of things. One is law and order. Second is public order. And third is security of state. So if something is if a person speaks something which is only which only challenges law and order, that is not a ground under Article 19. Unless a thing goes against public order or in the interest of public order, then freedom of speech and expression can be curtailed. So that way, if you want to curtail freedom of speech and expression on the ground of public order, you should have greater evidence. If you want to curtail freedom of speech and expression on the ground of security of state, better evidences are required. If you want to curtail freedom of speech and expression on the ground of national security, sovereignty, more and more stronger evidences are required. For law and order, almost for the purpose of law and order, generally you cannot restrict. For public order, you can restrict, but more good evidences are required. For security of state, better evidences are required. For national security matters, best evidence is required if you want to curtail freedom of speech and expression. Then is the next case is 1962 Kedarnath Singh case. Kedarnath Singh case is on the constitutional validity of section 124A sedition. So the court has declared that sedition law is constitutional. This has become very important these days because not only new cases are coming on sedition law. You know, again in Chhattisgarh, a police DGP has been charged under sedition law. Similarly, section 124A constitutional validity is again challenged in the Supreme Court, and Supreme Court has accepted it. This constitutional validity case was decided in 1962 by a constitution bench, and constitution bench said that sedition section 124 is unconstitutional unless there is a tendency of violence or disorder. So if I say something which is grossly offensive, which is very bad, but there is no tendency of violence and disorder, other laws can come in picture. Sedition law cannot come in picture. That is known as consequence test. So Shail Bala Devi, totality test. Ram Jilal Modi, aggravated form test. Ram Manohar Lohia, again, three circle test. Kedarnath Singh, consequence test. Balwant Singh case 1995. Balwant Singh case is on influence test. It says that if you speak something, and then in that case we have to see who is the speaker, whether he commands some influence or not. If the person who is speaking commands some influence over people, then only criminal law comes in picture. So what happened in this case, Balwant Singh case, after Indira Gandhi killing, two persons in Punjab, they came out, they were sick, and they were clerical staff, and they expressed their happiness on the killing of Indira Gandhi, and they said Raj Karega Khalsa, and they spoke something against India, and sedition case was registered against them. Then Supreme Court said that who are these people? They are simple clerical staff, and clerical staff has raised some slogans, and there was no influence of those slogans. If there are some influence of those slogans, then such type of slogans can come under criminal law. So if you are making some slogans and you influence students, you influence teachers, you influence community, then in that case the influence test comes in picture. Take example again, I go back to Prashant Bhushan case. Prashant Bhushan is a very seasoned, very reputed lawyer of the Supreme Court. He himself knows law. He has he has thousands of followers. Many people rely on that. So he had great influence. So suppose same tweet has been written by a student, it will not amount to contempt. But the tweet is written by an influencer like Prashant Bhushan or someone who has some influence, that type of thing will violate freedom of speech and expression. That is influence test. Then in 2018 case, Mazdoor Kisan Shakti Sangathan, Union of India 2018, it is also known as Jantar Mantar case. What happened in this case? That the Delhi government has issued an order that there is a complete ban. There will not be any agitation, any protest in Jantar Mantar. You have to go at some place, maybe Ramlila Maidan or some other place. Then it was indeed an order of the NGT, National Green Tribunal, directed this order that there is no protest on Jantar Mantar. Jantar Mantar is close to Parliament. Jantar Mantar is close to India Gate. Jantar Mantar is close to President House. Jantar Mantar is close to Cabinet office. So it is a place where if you protest, then press also can hear easily. People can also hear easily. So in that case, but when the ban was there, it was argued in the Supreme Court in appeal that if we are given a place somewhere else, who will listen us? So freedom of speech and expression does not mean I should criticize. My criticism should also reach to a particular place. Government must listen us. So if you give me a place, suppose you give me a place 50 kilometers away from Delhi, there is no benefit of that protest. We will protest in a place where government and media, they can listen us. So Supreme Court agreed with that and said that no, there cannot be a complete ban. Of course you can say that only 50 people can protest. Of course you can say that the protest will be only for maybe 1 hour, that you can do. So this is a very good case. Last two case that I want to discuss with you is that Amit Sahni case. Amit Sahni is in Amit Sahni case, it was held that we have freedom of speech and expression. There is no doubt. There is no doubt we have freedom of speech and expression. Do we have right to protest? Yes, we have right to protest. But that does not mean we can protest at the public place for a longer period. We can do it for 1 day, 2 day, 3 days. But if we do it for a longer period, we violate the fundamental rights of others. It was the CA protest which was going on peacefully. Of course, it was going on peacefully, even if it is a peaceful protest. But if it is in a public place, because of that, many people are having trouble. People cannot go to hospital. People cannot go to job. People cannot go to school. People cannot go to other important places. That is again violative of human fundamental right and human right, and therefore your fundamental right cannot violate the fundamental right of others. So Amit Sahni case, Shaheen Bagh case, the court held that even if the protest is peaceful, even if there is no disorder, you cannot make a protest for a longer period in a public place. Amit Sahni case. So this is how we discuss all Supreme Court cases. There are High Court judgments have also come, but I am not discussing those judgments because of lack of time. Thank you very much again to the team of Integral University. They have provided me the second opportunity. I am grateful to them for this opportunity. I request others, all those learned participants, to interact and strengthen this deliberation of free speech. Thank you very much. Your questions are welcome.
Thank you, sir. Very informative session and very well explained freedom of speech and expression. And it has generated enough curiosity amongst our participants. There are some questions from our participants which I want to take on their behalf. Sir, may I? Sir, should I take
Let
this
me
question?
there is a noise in my room. Let me close it.
Okay, sir.
Yes, please.
So the first question is from Mr. Ahmad Aman. Whether international institution has any mechanism to deal with free speech and its restriction in relation to cyberspace in the global village.
That's good. I don't think there is any enforceable mechanism except that uh, the UN bodies, human rights committees, United Nations can criticize the approach of a particular government. That they do. Uh, State parties sometimes also criticize the approach of government. The approach can be justified or unjustified. That is a different matter. Let me give you a small illustration. India government has issued in 2021 IT rules. which is applicable to all service providers, social media platform. Now, uh, one UN expert has addressed that this is quite wide, so they can criticize it, and they have indirect. Of course, they have indirect because UN body has influence. There, if they say something, it gets headlines. People quote it. So, if they are really justified, then the government must consider it. If they are because of ignorance, we should also ignore it. So when the government, when these bodies criticize us, when these bodies say that this is violative of fundamental right, violative human right, the government must listen very carefully, and if they find there is some merit in this, then they should mend their ways, they should improve themselves. And if they find that it is because of ignorance, it is because of sometimes some because of some propaganda, is it, if it is because of some pressure, if it is because of some cheap popularity, then the government should only decline and ignore it. So I don't think there is any enforceable mechanism under international law to impose this human rights doctrine of free speech. Thank you.
Sir, thank you. There's another question from our participant Sidra Khali. She wants to ask that how can poor countries with limited resources can maintain the same human rights standard as the rich countries?
Excellent question. Excellent question. I think this is I think one of the best question, I would say, because in last maybe 3 4 months I presented as many as around 10 or 15 lectures. Uh, so when the Constituent Assembly debate was going on, there was a fundamental right committee. This committee was headed by subcommittee, fundamental rights subcommittee. This was headed by Sardar Patel. When he proposed fundamental rights were in two parts. One part contained current fundamental right. Other part contained directive principles. So the directive principles were also a part of fundamental right those days when it was initially proposed. But the government found, and the, sorry, not government, Constituent Assembly found that it is very, very difficult to enforce those rights. How can you enforce economic rights? How can you enforce right to work for everyone? How can you enforce right to food to everyone? How can you enforce right to education to everyone? So therefore, they have deliberately changed the whole scheme, and one group was passed as a fundamental right, which was enforceable, and other group was passed as a directive principle. So this is a discussion and debate which is certainly very relevant for all of us. That it is sometimes very, very difficult for a poor country like India, and far more poor country like maybe Bangladesh, maybe Pakistan, maybe some other places, to enforce human rights. So there are two things that we should do. Number one, the developed countries have an additional responsibility. How did they get developed? How? They violated human rights, they violated environmental norms, and they get developed. They get developed. So it is a time to pay back. It is a time to pay back. So this is the principle that is in human rights jurisprudence under international law also, that the developed countries are consistently told for technology transfer, for environmental norms, for additional help to poor countries. Why? Because they have developed at the cost of environment, and developing countries cannot develop at the cost of environment because of norms have come in. So this is one that the developed countries should help. This is one. Secondly, developing countries can also do a lot of things. What are those things? There is a misfocused attention on so many things. We do not discuss on core issues of health, core issues of economic rights, core issues of labor laws. Uh, means Do you recall? Means let this house recall that because of COVID, we have started discussing on health. Else, in last many years, we have hardly discussed health the way we are discussing. When was the last time we have discussed the infrastructure of right to health of a poor person? Way back in means 80s, a permanent Katara judgment came in. But did we discuss right to health of a poor person? Did we discuss a Supreme Court judgment came in? But then okay. When was the last time there was a protest for right to health? We had a protest for right to speech, right to protest, and right to do this, right to do that. Sometimes right to religion also. So we are too much focused on religion, free speech, and other things, but we are less focused on health issues, welfare of laborers, welfare of domestic servants. We do not discuss these things. So the remedy is that we should also discuss religion, we should also discuss free speech, we should also discuss other things. But at the same time, we should not ignore right to health, labor rights, rights of domestic servants, rights of pavement dwellers, rights of people in the huts, rights of poor persons, poor students, so poor children. So these rights should also get equal focus. If we do this equal focus, means what? LLM students should do their dissertation work on this. If there are assignments, we should do this assignment on these economic rights. If there are PhD works, PhD scholars should do this, and the law teachers should focus more on these rights. Let me give you illustration that I am in the editorial board of ILA Law Review, and we do not find enough articles on these issues. We find articles on various other things. They are equally important. I'm not telling they're not important, but in the focus of that, we sometimes forget that there are voiceless people to whom the question is raised, that India is a poor country and we should address our poor people, and the resources must reach to those people. Which, if the resources are not reaching to those people, we should raise our voice. So more and more writing to right to health, right to laborers, rights of domestic servants, rights of pavement dwellers. More and more writings will, of course, change the scenario. Thank you.
Sir, very well explained. Sir, there is one more question from a participant, Alisha Khan. Uh, Her question is why globalization is leading to problems comply with human rights and trade union freedoms, the right to work and right to social security. It also shows a disproportionate effect on minorities.
Yes, I agree, completely agree on the question that globalization has led to, means, less social security of laborers, labor rights. I agree on that. Uh, Globalization and privatization is not an option; it is a compulsion. There are Supreme Court judgments on this, where let me give you a small example of. Uh, hmm, I am forgetting the case name of the case, where the Supreme Court observed that privatization is a compulsion because the government cannot do everything. Can the government give education to all? No. Higher education? We are not able to give primary education to all. What to talk about higher education? So yes, name of the case is Manuji Pragji Bhai case. Uh, Islamic Institute case also is there. In these cases, the Supreme Court has held or observed, not held, observed that privatization is a type of compulsion. So we cannot say that government should not privatize. This is one thing. This is one thing that we should accept. The earlier we accept, it is better for all of us. This is one. Privatization was not only because there was a global scenario, but it was also because many times the government sectors have failed to deliver. They were more concerned to rights than their responsibilities. Take example of many government sector. Why we failed? 20 years back, 25 years back, it was not possible to take a cell phone, a mobile phone connection. It was only monopolized by BSNL, only monopolized by MTNL. They could not deliver well, could not deliver well. Service was poor. So private sector came in. They invested, and now I think many of us are friends of and are fan of private sector. Uh, so it is correct that private globalization has led to privatization, and labor rights have been compromised. But at the same time, there should be a soul searching also. A very small example I'm giving you to West Bengal. West Bengal was ruled by the communist government for 30 years. Then we should think of that. Okay, they are supposed to be the those who have always talked about labor welfare. They were against capital. Labor was their core area. But what happens to West Bengal in 30 years? No good hospital facility, no good educational institute, no good industries. What is happening in? So that indicates that the reason is that we were more concerned to rights than to our responsibilities. We were more concerned to our payment than to the delivery. So if we are more concerned to our rights and then to delivery, certainly a time will come when the investment will be lower, and then privatization will come in. So the thing is that we have enough laws. There are laws to deal with private sector also. We have to just enforce it. We have Supreme Court judgments also, where directions have been made against the private sector also. We have only to enforce it. So as a student of law, we all are a student of law. We should know what law is, what are the Supreme Court directions, and we should only try to find, can those directions be enforced or not. Let me give you a small illustration. In one case, which dealt with asbestos. So employees, laborers were working in asbestos factory, and they used to get some time of ailment, and because of that they could not work. So the Supreme Court has passed various directions that is applicable not only to government sector but also to private sector, that insurance arrangements should be made, that even if they leave the job, there should be medical benefit to them. Are these things being enforced? We are not doing research work on that. I told you in the previous question, our attention is little more less focused. We are not doing much on labor rights, much on these. Of course, we are doing on sometimes on monetary rights, but not on the educational rights of minorities, more on the political rights. So while we should carry on with political rights, we should equally focus on these economic rights of people. So if we focus on that, I think there can be some solution. Thank you.
Thank you, sir. There are a number of other questions, but due to time constraint, I cannot take all the questions. But I would
You can, yes. My request is you can take one or two more questions, because I don't have at least time constraint. I understand you have next session. I don't have time constraint. I will really be happy to answer all the questions, but you can take at least one more question.
Sir, I will take one more question. This question is from our participant Amit Shukla. He asked that how to make a balance between emerging phases of fundamental rights and increasing restrictions over fundamental rights, which is one of the crucial factors of welfare.
Uh, yes. So I think when we talk about increasing restrictions, uh, means restrictions are increased two ways. One, that uh, on record restrictions are increasing. So fundamental rights have not been amended. There are no further restriction. 1963 onward, there was no restriction on fundamental right. Of course, fundamental duties were incorporated. That again is a part that again shows there are some restrictions. So in the constitution, no such restriction is there. No such restriction. Is that the restrictions have not increased when after 1963. Second restriction is that through executive measures, some restrictions are there. So when the scope of right increases, take example, we only had newspaper, then the newspaper changed into news channels, and now news channels where maybe 1 hour, 2 hour, 6 hour news channel, only Doordarshan. Then we came to 24-hour news channel. After 24-hour news channel, now we have online media. There is no need to bank upon or rely on only news channels. There is no monopoly of news channels. There are small news channels, news websites have come, which are doing extremely well, extremely well. So, so our freedom of speech and expression, our scope and our expression has further increased due to social media. If you read Times of India, 20 years back, you had to write to Times of India that you agree on this view or don't agree on this view. But today, Times of India, you can immediately write your comment and that will be displayed immediately. So your expression gets a platform immediately. So NDTV has a show. They also give it in a website. And you can immediately say you agree or disagree. You can give your views. So in a sense, our freedom of speech and expression had got new platform. We are no more, that is no more the monopoly of big business groups. We can also express ourselves there immediately. And we also comment there. Live law comes, bar and bench comes. So you can express your views immediately. So that is one thing. So our rights have increased. But at the same time, rights have become some of the people do not know the difference between responsible speech and irresponsible speech. And irresponsible speech is sometimes protected if you speak something, but that does not harm anyone. But when you go for destructive speech, when you go for subversive speech, when you go for defamatory speech, then some action has to be taken. And therefore, executives take action. Now, executive actions can be of two types. One that is justified, other which is not justified. And both are increasing. I have given you one example of Chhattisgarh, how a sedition case was registered. There could be other cases. In UP also, take example of Kafil Khan, where NSA was imposed. When he said something in a gathering in Aligarh Muslim University students, he might have said which may not be appropriate. There was other laws also. For example, 108 of CRPC, which does not need any arrest, but instead NSA was imposed on that. So if it is unjustified, every unjustified thing must be opposed like anything. It is our responsibility to oppose, be they from Congress party, be they from BJP, be they from Communist party, be they from any party or any ideology. Why? Because we are the soldiers of human rights. We are the protectors of constitution. We are the gatekeepers of these fundamental rights. Not just Supreme Court is gatekeeper. We are also gatekeeper. How can we protest? We can protest through social media posts, through Facebook, through Twitter, through other places, telling that we do not agree on that. But one thing I would only say, that when we protest against the executive action in order to balance fundamental right, that is the main question. When we protest, we should be impartial and objective. We should not be selective, that we will only take particular type of we will only protest against particular type of criticism and leave other types of that. So we should not do it. So in order to balance between emerging fundamental rights and emerging restriction, Supreme Court has itself given a principle of proportionality. Executive should do it, but if executives cannot do it, it is the responsibility of the courts to do it. And if courts also fail, then it is the responsibility of academician to tell them that this is right and this is wrong. Thank you.
Thank you, sir. And now I request Dr. Avinash Kumar to present vote of thanks to our resource person. Dr. Avinash Kumar, please.
Thank you. Thank you, sir. So, good afternoon, one and all. As we come to the close of this session, I, Dr. Avinash Kumar, Assistant Professor, Christ University, Delhi NCR campus, first on my own behalf and on behalf of the entire fraternity of the Integral University, would like to express my pleasure to deliver this vote of thanks. In the beginning, I would like to thank the convener, Dr. Mirza Junaid Beg, sir, and the coordinator, Ms. Sipra Mishra, for organizing such a wonderful event. I wish also to record our sincere appreciation to Dr. Anuragdeep sir, Associate Professor, Indian Law Institute, for giving us time for his busy schedule. And sir, you discuss very well about the human rights. I have seen the definition and about the freedom of speech and expression from the preamble to the Article 19(1)(a) or and the other international covenants. But sir, I have seen you on the television also, and the last seminar or conference that was on sedition law, you were speaking on the sedition law. That time I have seen your inclination about the sedition law, but today I am very happy to see you in this context about the fundamental rights and the protection of the freedom of speech and expression. So that's a wonderful lecture, sir. And this type of, so thank you very much, sir. And this type of event cannot happen overnight. So the wheels started moving about a month back. It requires planning and bird's eye for details. I want to thank each one of you for your commitment, for your dedication, for your time, and the extraordinary work that you all are doing in indeed difficult circumstances. So thank you each one of you for sparing the time. Last but not the least, I also want to thank all the participants from the different universities and the different organizations, as your participation has made this program a successful event. To conclude, let me once again reiterate my gratitude to all. Thank you, everyone. Have a pleasant day. Thank you. Thank you, sir. Thank you, Abhishek, sir. Thank you, Anurag, sir.
Thank you,
Thank
Avinash.
you, sir.
Thank you, Anurag, sir. We will look forward for future association with you, and I hope that our association will grow stronger day by day.
So nice of you, sir. Thank you, everyone.
Thank you, sir.